for Heffron.
Madam Deputy Speaker, I make a contribution to the Reproductive Health Care Reform Bill of 2019. I have listened to the views of members of this place, as has my office received hundreds of emails from various people of different particular positions. One thing for sure, though, in respect of all of those submissions, or almost all of those submissions, is nobody knows what the actual law is in New South Wales. To listen to members of this House to assert that Section 82 to 84 of the Crimes Act 1900 makes abortion illegal in this state and therefore it needs to be decriminalised is erroneous, because the law is not contained simply in sections of the statute. The law is a body of law that also encompasses decisions of the courts, called the common law. It is wrong to assert that as a basis that requires this legislation. Secondly, those, and most of those who have contacted my office, seem to be of the view that abortion is legal in New South Wales and therefore this bill proposes to make it legal. That view is also wrong. For almost 50 years, abortion has been permitted by the law in New South Wales. The common law, as determined by the courts, has consistently applied the principles determined by District Court Judge Levine in the Queen against Wald, reported at 1971, 3 District Court reports, New South Wales, at page 25. And that is that where a woman honestly and reasonably believes, on any economic, social or medical ground or reason, that the pregnancy constituted a serious danger to her physical or mental health, a woman has the right to terminate a pregnancy. The courts have declared the law to be that the relevant factors for determining whether the pregnancy constituted a threat to the physical or mental health of the mother included the social and economic circumstances that it would apply subsequent to the birth of the child. That's a decision of the Court of Appeal in CES and Super Clinics Australia Proprietary Limited, reported at 1995, 38 New South Wales Law Reports, at page 47. In fact, in 1995, the then Premier Bob Carr observed, quote, "In my view, an abortion is a matter responsibly left for discussion between a woman and a doctor, and that's the position we will take in this state," unquote. Bob Carr's position merely reflected the common law of this state. Effectively, that means that since 1991, abortion by demand has existed in New South Wales. The question therefore is, why the need for this legislation at all? My experience as a member of this House has indicated that whenever legislation is introduced that serves very little purpose, there are always unintended consequences. With the best will in the world, the Parliament does not always get it right. At best, even if it engages in a detailed consultation process, the Parliament can't possibly imagine every conceivable act or person or organisation it attempts to regulate that it can actually foresee at the time of enacting the legislation. It therefore has to trust the courts to interpret it in the future. At worst, this Parliament legislates because of a newspaper headline or alternatively a broadcaster's opinion for purposes other than the real reason that the legislation is enacted. And so consequently, simply legislating for the purposes of some philosophical view always has unintended consequences. Because on one view of it, this bill, part of this bill, is far more restrictive than the common law. And I am sure that that's not what's intended by those who sponsor this bill. I am critical of the fact that the normal legislative consultation process has not been engaged in. Not because any view or philosophical view I have about abortion, but because we have not enabled people to properly have their input. In relation to the many hundreds of people that have contacted my electorate office, and most are opposed to this bill, I wanted to convey to them that their understanding of the law in New South Wales is wrong, that in fact abortion is permitted in New South Wales, and I wanted their input about this particular bill. But I was denied that opportunity, even though I've been able to write to them, because before I'm going to vote on this bill, they're not going to have an opportunity of getting back to me. Now, I've heard members of the government, I know this is a conscience vote, talk about the fact that the way in which the bill has been rushed through is not appropriate. But it was last Thursday that they voted to enable this bill to be treated as government business. And this bill is before the House, not in accordance with any standing or sessional orders, and not in accordance with any resolution of this House suspending standing or sessional orders. And so the reality of the situation is people were entitled and are entitled to be consulted. And the reason that they're entitled to be consulted is this. And not because most of those people that have been vocal are opposed to the bill, because the nature of this issue requires decisions to be made that, as best as possible, we can take people with us. This is an issue that has divided nations around the world. I mean, the world's most powerful democracy to this day is bitterly divided on this issue. Ever since the US Supreme Court determined in Roe and Wade at 410 United States reports at 113 in 1973 that the right of a woman to choose to have an abortion without executive government restriction has divided this nation. To this day, associate justices are appointed to the Supreme Court, either nominated by the executive or approved by the Senate, based upon whether or not they will overturn what's known as Roe v. Wade. It is a hugely divisive issue. I accept, though, in Australia and in New South Wales, that the community is slowly moving in a more progressive way. We have seen it in in the debate and the plebiscite on gay marriage, and this is an area where I discern that the community are beginning to move. But you want them to move with the Parliament. We want them to have their say. We want them to not feel disenfranchised. And the way in which we've embarked upon that exercise, I believe we have done just that. However, despite them being denied their right to consult, despite this House considering a bill in breach of its own standing and sessional orders, I'm required to come to a view about this bill. I will bring to my view about this bill my knowledge of human affairs, my knowledge of the law, and my own philosophical position. I told this House on the 7th of June 2018 in the Public Health Amendment Safe Access to Reproductive Clinics Bill, my long-held view. Madam Deputy Speaker, might I have an extension of time?
The question is that the member's time be extended. All those in favour say aye. Those against, the ayes have it. The ayes have it.
I have believed prior to the Queen and Wald and Roe v. Wade, but prior to that, I have believed in the right of a woman to choose. I reject the pro-life or the pro-choice badges. I believe that a woman has a right to choose. During my lifetime, I have known people who have terminated pregnancies and have faced that position. I have supported people. I have acted for them. I have witnessed and seen the results of the scars that are left. I don't think any single woman who is pregnant arrives at a decision to terminate a pregnancy lightly, and I had those views confirmed by the obstetricians I spoke to yesterday. I have seen the impact of school children as a young teenager myself, when sex was taboo, and when sex before marriage, I should say, was taboo, when contraception was taboo, let alone abortion being illegal, and young school children faced with a pregnancy from a religious family, struggling to tell their families, let alone securing the termination of pregnancy when it was illegal to do so and was hard to obtain, contrary to a philosophy of their own families. I have seen in those days in the late 60s and heard of them because I was around at the time of the backyard abortionists, the unqualified people who terminated pregnancy and injured women and girls who are desperate for termination. No law will stop it happening ever, because no law is going to impede upon a woman's right to choose. The US Supreme Court recognised that in 1973, and the courts have recognised that in New South Wales since 1971. No man can impose in my opinion, their view upon a woman's right to choose, because they can never place themselves in that position. It is fine to have a religious belief or a philosophical belief. It is fine to try and advocate those views. But for somebody like me, who will never ever be in that position, I cannot vote to impose that position on another woman who is pregnant. Accordingly, I will do what I have done virtually my entire adult and teenage life. I will support the concept of a woman's right to choose, and if I am required to vote on this bill, despite my concern about its utility, I will vote in favour of the bill.